Welcome to Conservatorship of Minors 101. My name is Tim McKinney, and I'm a lawyer with the firm of Reynolds and Nicholson, and I'll be your instructor. Now, a conservator of a minor is charged with the management of a child's assets and finances and accepts the responsibilities that go along with that. Acting solely for the benefit of the minor, the conservator ensures that funds and property of the minor are invested, protected, and preserved for the minor to be delivered when he or she reaches the age of 18. It truly is an awesome responsibility. And as part of the volunteer work that my firm does, we're trying to help you understand what's required of you. Before we get started, though, let's go around the room and briefly introduce ourselves.
Hi everyone, my name is Lori Barnett, and recently my sister and her husband were killed in an automobile accident. Since that time, I've been caring for their two children, Sarah and Lisa, and I've just been appointed as their guardian and conservator.
I'm very sorry for your loss, Lori.
Thank you.
Hi, my name is Shona Westbrook, and this is my husband Al, and we're here because our daughter was in a boating accident, and we need to be appointed as conservators because there's going to be an insurance settlement.
Nicole's 13. She has a lot of good friends who are helping her and us.
I'm Robin Smallwood. I'm a police officer, and the reason I'm here is my daughter inherited a life insurance policy from her father, and I was told I had to take this class.
Okay, interesting group. Let's get started today with some basic definitions. Conservator, minor, natural guardian. What do they mean? Well, first, a conservator is someone who's been given legal authority over the funds and property of another. A conservator is entrusted to not only manage the minor's property and funds, but to do so with undivided loyalty and in the best interest of the minor. Next, and you probably already know this, a minor is anyone under the age of 18. And here's a term that may be new to some of you, natural guardian. Anyone?
That's us, right? We're Nicole's parents, so we're her natural guardians.
Right. Parents are natural guardians. If the parents are divorced and one parent has sole custody, that parent is the sole natural guardian. If one parent is deceased, the surviving parent is the natural guardian, and the mother of a child born out of marriage is the sole natural guardian. Though this class doesn't really cover guardianship of minors, it would probably be helpful for you to understand the difference between a guardian and a conservator. A guardian decides where the child lives and makes medical, educational, social, and religious decisions for the child. A child's natural parent automatically has these responsibilities. A conservator, on the other hand, manages only the minor's property and money. A conservator may or may not be the child's parent or guardian. Now, in most cases, if there's a parent in life, the parent will be appointed conservator, if qualified to serve. Now, in your case, Lori, you are both a guardian and a conservator.
Right. I had agreed to take care of Sarah and Lisa, so I became their guardian. But my sister and her husband left everything in their will to Sarah and Lisa, but didn't leave it in a trust, so I also had to become their conservator.
That's right. Anytime there are assets involved and a minor has no natural guardian, a conservator has to be appointed regardless of the value of the inheritance. Now, you are Nicole's natural guardians, but now that she's entitled to a significant settlement, you have to be appointed as conservators to care for her assets. Now, either one of you could have done it, but you decided to do it together as co-conservators.
Your settlement had to have been more than $15,000 since you're the natural guardians. I mean, that's why I have to get appointed. I know they trust me with $15,000, but because my husband's policy is $25,000, I have to answer to the courts. I mean, come on, you would figure they would trust a mother that's a Cobb.
Robin, I appreciate how you feel, but the law looks to protect all minors and their assets. Some monetary level had to be set for the minor's estate to require a conservator, and there's really no way for the court to determine which parents ought to be trusted and which not. Okay, you notice I just used the word estate, which means all the combined assets of the minor. Personal property, money, stocks, everything the child owns, except that any real estate is generally excluded when determining whether a conservatorship is necessary. Now, anytime a minor's estate in personal property exceeds $15,000 in value, whether it's from a personal injury settlement, a gift, or an inheritance, a conservator must be appointed, even if a natural guardian is alive.
So because I'm not my niece's natural guardian, they would need a conservator no matter how much or how little their estate is?
Correct. In addition, if real estate is involved, only a court-appointed conservator can sell or mortgage the property, no matter what its value. Now, looking at our graphics, we see that in a conservatorship, the minor has certain rights: to have a qualified conservator who's reasonably available, to have his property used to help provide for his support, and to have his property and funds surrendered to him at age 18. A conservator also has responsibilities to the minor. As a conservator, always act in the minor's best interest. You're to provide for the support, care, education, health, and welfare of the minor, taking into account all available resources, income, and support. A conservator must understand that the fact that a minor may have funds or property does not relieve the legal responsibility of parents to support the minor. If you're a parent or a natural guardian, you are legally obligated to support the minor by providing food, clothing, shelter, health care, education, and other necessities. And that obligation remains even after the child may receive money or property. Now, in most cases, a conservator should focus on preserving, protecting, and investing the minor's assets and then delivering them over to the minor at the age of 18. Sometimes, however, some of the funds in an injury settlement for a minor are designated for future medical treatment. In such a case, you may expect to expend those funds for that purpose. Other times, the court may grant an expenditure of a portion of a minor's assets if it feels that the request is truly in the minor's best interest. For example, if a minor has certain needs which the family can't afford, the court may grant an encroachment.
Tim, frankly, Nicole's settlement is quite large. I mean, we can see where Nikki could benefit from a membership to the Y, where she could do stretching and exercises in the water. But we feel a little funny saying that she can have this Y membership, but her brother and sister can't because we can't afford it.
I know your concern is to be fair, but the court's concern is in using Nicole's funds for her benefit alone. The court may allow for a Y membership for her physical rehabilitation, but it's unlikely that it would allow Nicole's funds to be used on her brother and sister. However, each case is considered on its own merits, and there are a lot of factors that the judge may consider, and the court may appoint what is called a guardian ad litem to help determine what's in the minor's best interest.
Okay, but this settlement will open up a lot of new possibilities for Nicole. Do you think the judge would consider allowing us to use some of these funds to send her to private school?
Another good question, but I just don't know the answer. I would think that the court would consider the quality of the local school system, your willingness and ability to pay some of the private school expenses, and the impact on the other children. You'd be called upon to show that you and Shona could not afford to put Nicole in private school without using some of her money. The courts often prefer to keep the minor living in the manner in which he or she was accustomed to before the money or property was received. However, I believe you'll find our probate judges to be understanding if there are compelling reasons that might positively impact the child's future.
My situation seems a little bit different. I would love not to touch any of Sarah Lisa's inheritance, but I just don't think I can support them without some help.
Well, as I said, every case is unique, and your situation is quite different. First, I assume that your nieces receive Social Security survivor benefits or some equivalent. The court will want to know the amount of those benefits as well as any other sources of income for the support of the children. Now, you are not their natural parent and aren't legally responsible for their support. I believe the court would be inclined to be more lenient in a case such as yours, while still balancing what's in the children's best interest. You'll want to put together a budget, giving the children a reasonable lifestyle. If their Social Security and other income is insufficient, I'm confident that the court would give due consideration to your request to encroach. Now, the first thing you'll need to do is estimate the income from the conservatorship. A conservator can usually spend the income generated by the child's money for the maintenance and support of the child, but the court may choose to restrict the expenditure of the income as well. Income consists of all interest and other income from investments and property held in the conservatorship. However, you cannot touch the principal without getting permission from the court. Principal, or corpus as it's sometimes called, consists of the assets in the conservatorship, including funds and accounts and other investments. Next, let's continue with the responsibilities of a conservator. When you petition to become a conservator, you must show what funds or property exist or will be received that make the conservatorship necessary. You have to post a surety bond to cover the value of the funds or personal property received by you as conservator. Anyone know what a surety bond is?
Yeah, it's like an insurance policy for your child's money, in case you mess up.
That's right. Every conservator is required to post a surety bond so that if the conservator mismanages, misappropriates, or loses the minor's funds, the minor will not suffer loss.
I heard it's sometimes difficult for people to get bonds for conservatorship, even parents.
Unfortunately, that's true, and it's one of the reasons why the county conservator is often appointed. If someone has a bad credit history, a criminal background, has been in bankruptcy, or is unemployed, he or she usually cannot get a bond. The bonding company just considers them too great a risk. Insurance companies don't like to pay out losses on surety bonds.
There you go. Not only don't they trust me, but I have to pay some kind of insurance policy for what? Like it's steal from my own child?
Of course you wouldn't, Robin, but I'll bet you've heard of someone committing a theft that you never would have believed possible. That's why every conservator has to be bonded, no exceptions.
Okay, so what if the conservator mismanages the money? Just a professional curiosity.
Believe me, you don't want to know. I've got a DVD that we're going to play a little bit later on that shows you the worst that can happen. For now, though, let's get back to the conservator's responsibilities. A conservator is also required to notify the court of any conflicts of interest that arise between him or her and the minor.
I'm not quite sure I understand. Can you give us an example?
Sure. Probably the most frequently seen conflicts of interest is when parents who are conservators seek the court's authority to spend their minor's funds on things which the parent would normally be expected to pay for anyway. When that happens, most judges will want to know the answer to this basic question. What would you have done if your child didn't have this money?
Hold on a second, Tim. My husband meant for our daughter to enjoy this life insurance. That's why he bought it. Why can't I use it for her now? I mean, why shouldn't she be able to use what's hers?
Well, Robin, it could just as easily be said that your husband was depending on you and his Social Security benefits to take care of your daughter while she's a minor, and that his insurance was meant to provide her a nest egg for when she's an adult and hopefully considering college.
Point taken. But I bet he thought I'd be the one to decide when and how it's spent.
Probably so. Okay, another possible conflict of interest would be employing and paying relatives to provide care for the minor. The amount of payment would have to be set by the court. Buying property or selling property or services to one's minor ward is considered a conflict of interest and should be avoided as well. All right, so next let's talk about money management. What might you do with your ward's money? Al?
Well, I guess it could be invested in some kind of asset that's earning some interest.
Good suggestion, because the income can increase the value of the minor's estate. Any asset other than money which can produce income should also be used for that purpose, unless there's a compelling reason otherwise.
Can you give us an example?
Sure. For instance, Lori's nieces may have inherited rental property, but let's just say that Lori doesn't have the time to find renters, collect rent, deal with repairs, so she may decide to petition the court for leave to sell. The court would then review the proposed sale to determine that the sale and the terms were in the children's best interest.
If my nieces inherit stock, which I think they will, can I sell the stock and then put the money in a less risky investment?
That may be a very good idea, especially if you know little about the stock market. A conservator may retain stock investments that come into the conservatorship, but a conservator is only allowed to make new investments in what are called legal investments. CDs, money market accounts, obligations of the United States government or the state of Georgia, savings bonds, municipal bonds. So you can sell the stock and put the money into any legal investments. However, you would need court authorization for any new investment in property such as real estate, stocks, mutual funds, or bonds, all of which are considered to be risk investments. And you might need to show that you sought the advice of an investment counselor or attorney before petitioning. It may be appropriate to consult a stockbroker or a financial consultant or certified financial planner if you feel the size of the minor's estate warrants it.
This is getting a little confusing. How do I know when I need the court's permission to do something?
Well, it can be somewhat confusing, but here are some guidelines. You cannot sell, rent, exchange, assign, mortgage, or give away any of your minor's real or personal property without court authority. So for instance, if you need to sell something in the conservatorship to support the minor, you'd first have to file a petition for leave to sell. A conservator may not spend more than the minor's annual income without court approval. Some conservators may be restricted from using even the income. Expenditures of the minor's income, when permitted, must be for the benefit of the minor and not to support the child if there's someone obligated for support. Any expenditure which would tap into the minor's principal must be approved by the court, even if it's obviously in the minor's best interest. For instance, Shona and Al, you would have to petition the court for permission to encroach if you wanted to install exercise equipment to help with Nicole's physical rehabilitation. Anytime you're unsure whether an action or expense requires the court's permission, you should find out first. Acting without proper authority is one of the biggest problems the court has with conservators. Court clerks can usually tell you when the court's authority is required. However, court clerks cannot and will not give you legal advice. You should maintain a relationship with your lawyer because you may need to consult with him or her from time to time. Okay, so next let's talk about getting property transferred over to you as conservator and setting up bank accounts. First, using your letters of conservatorship, which is the court document identifying you as conservator, you'll get all of your minor's property titled or registered in your fiduciary capacity as conservator. Set up everything so that the title, account, or deed will read, for example, Al and Shona Westbrook as conservators for...
Nicole Westbrook. And it belongs to her, right?
Exactly. Whatever comes into a conservatorship is still owned by the minor. The conservator is just managing it. Now, most of you will be receiving cash for your minor. Make it clear to the bank that you're setting up conservatorship bank accounts, not joint or custodial accounts. Don't put any of your own money into the conservatorship accounts. If you've already opened up accounts for your minor with your own money, or if you do so in the future, keep those accounts completely separate from the conservatorship accounts. If you commingle them, all the funds become conservatorship funds.
Tim, bank accounts don't pay a lot of interest. Where else could we put Nicole's money?
Only in legal investments, CDs, money market accounts, obligations of the United States government or the state of Georgia, savings bonds, municipal bonds. You can get a complete list from the court.
Well, you won't make any kind of decent returns on those investments.
You may not make as good a return, but keep in mind that legal investments are guaranteed against loss. All right, so next, let's talk about good record keeping. There are financial reports which you must file, and your accounting has to be accurate. The only way you're going to be able to do that is by keeping good records. Remember that you can be held personally liable for expenditures if you're not able to properly account for them. So think of this as a new part-time job. You're going to be your minor's bookkeeper, and your records are going to be audited every year by the court. Therefore, it's important that you always pay by check and write the information in the check register. Note who the check was made out to, the amount, and the purpose for the expenditure. Now, you and I might not usually write down the purpose for every check, but you must do so as a conservator. Get a receipt whenever possible. Never pay with cash unless you absolutely must, and never use an ATM or debit card for withdrawals on a minor's account. Keep all bank statements and canceled checks, and keep all of your records organized and together in one place. Now, your first court filing requirement will be a form called the Inventory and Asset Management Plan. Now, this must be filed within 2 months of your appointment. In the first part of the report, the inventory section, you'll describe and list the current value of all assets that your minor owns. Any real property, stocks, bank accounts, anything of value which has come into the conservatorship. The inventory provides the court a full and accurate value of the minor's estate, which may have only been estimated previously. The inventory also allows the court to determine if the posted bond is sufficient to cover the full value of the minor's estate. Now, the court may require you to provide verification of all account balances in the form of original statements, as well as proof that all conservatorship accounts have been properly titled. Now, the second part of the report contains your plan for managing your minor's money. Now, here you have two choices. If you don't plan on spending any of the minor's funds, you may simply note that fact, and you will not be required to prepare a budget. If, on the other hand, you expect to expend any of the minor's funds, you must prepare a budget of the anticipated living expenses for the minor and the income and support available for him or her from all sources. Now, if someone is obligated to support the child, those living expenses which would normally fall upon such person would generally not be considered by the court in your budget. unless that person shows that his or her income is insufficient to provide full support. If there's no one who's obligated to support the minor, then all living expenses should be shown. Now keep in mind, too, that there is a court cost for each petition filed, as well as for filing the required inventory and annual returns. When you can include an encroachment request with your regular budget, you'll save the time and expense in filing separate encroachments.
So, in the budget, I would show what it takes to support my nieces in the manner that they're accustomed to living while their parents were alive. And then I would include their Social Security benefits and any expected income from the conservatorship. And the court would allow me to make up the shortage from the, what did you call it?
The principal. Yes, typically you would either use a reasonable portion or a percentage of all household expenses in the budget, or you may want to ask the court to agree upon some reasonable amount for room and board, and use that figure plus any particulars such as medical expenses or private school tuition to arrive at your monthly budget. Then, if the income they receive in the conservatorship is not enough to cover that, you'd ask to spend the amount necessary from the principal. All right, so we've covered the highlights of the inventory and asset management plan. Now let's discuss the annual return. This is the report which is filed every year within 60 days of the anniversary of your appointment. With each annual return, you must also file an inventory and asset management plan, updated with any new information. Now, there's not currently a standard form for the annual return, so yours may look a little different than the one we're using in class. Now, here we see that you are to give the beginning and ending balance for each account held by you for the minor, as well as the total of all receipts and expenditures for each account. So for the first account listed here, there was a beginning balance of $23,912, $1,076 in total receipts, minus $1,215 in expenditures, which gives an ending balance of $23,773. Now, you'll also be required to provide a current bank statement or a certificate signed by a bank employee verifying the ending balances. The first page of the return is a summary accounting combining the totals from all accounts. Now, your bond may have to be increased or decreased based on the combined ending balance, but the court will decide that. Now, on the next page, for each account, you're to show every transaction that took place during the previous year, including every deposit and deduction, the date, check number, payee, and purpose. If you use money management software, you can print out a transaction report containing all the same information. Now, some annual return forms will ask you to provide the information in a different way, listing the total amount spent in different categories, which is also easy with computer software. Now, you're required to maintain all records and supporting documents until your return has been approved. However, it's recommended that you maintain all returns and supporting documents throughout the duration of the conservatorship. Now, this may not apply to many of you, but if the minor's income requires that a tax return be filed, it is your legal obligation as conservator to do so. Depending upon the size and complexity of the minor's estate, you may want to seek the help of a tax preparer. Before we conclude the class, you may be interested to know that you are legally entitled to compensation for performing your duties, though many conservators prefer not to accept any compensation. A conservator is entitled to a commission of 2.5% of all monies received into the minor's estate and 2.5% of all monies paid out of the estate. A conservator may receive a 10% commission on all interest income earned each year, but not in addition to the 2.5% on receipts.
Tim, this is crazy. First, they don't trust me with my own daughter's money. Then they think I'm going to charge her a handling fee. I don't get this. I would never use any of it, except for her.
Well, a lot of conservators feel that way. Just remember, if you do take compensation, there is a specific formula to use. Don't just pay yourself your hourly wage if you take time off of work. Well, that almost wraps things up, but before we do, many conservators and guardians have asked us what happens if they fall short in their responsibilities. And to answer that question, the court has prepared this short DVD.
Therefore, judgment will be rendered against the former conservator and the surety in the amount of $29,812.78 plus all costs of court. Mr. Jones, you and the surety are hereby ordered to pay over those amounts within 10 days. Your failure to do so may cause you to be held in contempt of court. You are excused.
Okay, we need to talk about how we're going to set up these payments.
Most conservators for minors successfully carry out their responsibilities with little difficulty. There are those, however, who will not take the obligation seriously, who will not adequately fulfill the reporting requirements, and even a few who will actually take a child's money and spend it on themselves. Complaints may come from professionals, agencies, or even family members. But the problem most often starts, as it did in the case I've just tried, when a conservator fails to file a return on time. The court mails the conservator notice to do so, which goes unanswered. Then a deputy sheriff shows up at the conservator's home, serving him notice to appear in court. There, the conservator must explain to the judge why he has not complied with the law and why he should not be removed.
Your Honor, please keep in mind that this is the first time that my client has been called into court.
Your Honor, we respectfully request that Mr. Jones be given a second opportunity to file that return.
Even if the judge decides not to remove the conservator, there will be costs and expenses which must be paid out of the conservator's pocket. If, however, the judge finds that monies have been mismanaged by the conservator will be removed and a judgment will be entered against the conservator and the bonding company. If the conservator does not promptly pay the judgment, the bonding company must. The bonding company will then pursue collection from the former conservator. It might garnish his wages or bank accounts. It will add interest on the outstanding balance. These actions usually adversely affect the conservator's credit rating, making it difficult for him to buy a car or obtain any other credit. If there has been theft, fraud, or any other criminal activity, including perjury, to cover the matter up, the court might turn the case over to the district attorney for criminal prosecution. In the end, the conservator's reputation might just be ruined forever among family members and friends. That's why if you think the responsibilities of handling another person's money might just be too great for you, it's best to leave it in the hands of another, such as the county conservator. As a probate judge, I took an oath to perform the duties of this office, which include requiring all conservators to comply with their duties. As a conservator, you too take an oath that you will well and truly perform your duties. Unfortunately, when a conservator doesn't play by the rules, the court must take corrective action, which at times can be harsh. We trust that by having watched Attorney McKinney's great Conservatorship for Minors 101 course, you will never find yourself in that position.
Well, this really does conclude our class. But before excusing you, I want to tell you about some resources that may be helpful to you as you serve as a conservator. First, your court may provide you a handbook for conservators for minors in Georgia, which covers most of what was covered in this class. And you may want to visit the Georgia Council of Probate Court Judges website at www.gaprobate.org. There you'll find a great deal of information, including the handbook if you didn't receive one, and links to several probate court websites. So, thank you for coming. Thanks for your attention and observations, and I know that you're all just going to do a great job as conservators.